Welcome back to the Politics with Paul podcast, your home for nonpartisan discussion of political science and civics. I am your host, Paul Rader. Another guest episode is on the way today, as you can see. And for anyone who is new to the show, I always start off with a disclaimer that I do not take a stance for or against a guest's political views or groups they support. But regardless of your political persuasion, the power of the presidency has undoubtedly expanded over the course of U.S. history, both with Democrats and Republicans, and even with the now defunct Federalists and Whigs. But has it gone too far, especially in recent decades? Does it break the separation of powers doctrine that is intrinsic to the U.S. Constitution and the system of checks and balances that goes with it? And if it has gone too far, how do we rein in the presidency and the overall executive branch? Well, that's what my guest, Peter Cohen, is here to talk about today. Peter just retired from active legal practice this year, but he has over 40 years of legal experience, including civil litigation, legal writing, editing, and appellate advocacy. He also used to be an adjunct professor of law, teaching landmark U.S. Supreme Court decisions, constitutional foundations, due process, judicial review, and, especially relevant for today, cases addressing presidential authority. Now, Peter brings that experience to his book he just released this year, titled, In the Supreme Court's Own Words, First Principles for Checking Presidential Power and Preserving the Republic. So, let's talk about his book and its insights into presidential power and whether that power is going too far. Please welcome Peter Cohen to the show. Peter, thanks for coming on. How are you?
Very well, and thanks so much for having me.
Yeah, absolutely. A couple of previous episodes I had done had been sort of along this path of the expansion of the presidency over time, but it's nice to get somebody who's much more ingrained in that field, that has a lot more insights to provide to sort of build on that conversation. So
Sure.
Let's go sort of back to the beginning with you. I like to do that for the first question. So before even writing this book, of course, we'll get to that shortly, but I mentioned you just retired from being an attorney. So can you give us some more details on your experience with legal cases concerning presidential power, whether it's trying a case, writing opinions and commentary, or teaching cases as a professor?
Sure. So my focus on presidential power didn't begin with presidents at all. It began with abuses of governmental power, and particularly at a very human level. My first job out of law school was with a public interest organization representing indigent criminal defendants, including in capital and death penalty cases, which is the ultimate life and death power that the government could ever exercise. We were oftentimes the last line of defense for people who had no power at all. And in those cases, everything turned on the constitutional limits on governmental powers. What can government do? What can it do? Who makes that decision, and the like. So I was exposed early on in my career to questions of governmental power, the wielding of governmental power, and the constitutional limits on governmental power. And that experience shaped me for the past 35 years as a trial and appellate lawyer. I handled hundreds of cases that involved confronting institutions such as employers, corporations, and many times government actors within the executive branch headed up by the president who exceeded their lawful authority. It was also during that time that I developed a strong interest in research and writing. And in fact, that was always the aspect of law practice that I always enjoyed the most, and particularly Supreme Court decisions, hundreds of which I had to analyze down to their essence and explain in an understandable fashion at all levels of the judiciary. The focus more specifically on the limits of presidential power emerged years ago when I began teaching constitutional law to both U.S. and international law students, and particularly international students who were most interested in learning what kinds of constitutional limits do we place on the highest executive officers in the land, because many of them came from countries where they had no such limits on their executive officers. So in the course of teaching, we delved into the Constitution, the origins of the Constitution, the separation of powers, checks and balances among the various branches of government, and in particular, and more specifically, the constitutional limits on the presidency, which form the foundation of the book. So for me, studying not so much the abuse of power, but the excesses of power, and in particular presidential power and its limits, has very much been an evolving process over time.
I think that's a good distinction to make there, actually, those abuses versus excesses, because sometimes it's not necessarily something that a president or a governor or mayor or whoever, they don't necessarily do something illegal, but it is something that you say, well, that might be unethical. Is this something that we should outlaw? That sort of thing. And of course, make a great point where for all our grievances about our governments, especially whether it's a chief executive or anything like that, a lot of people, a lot of international students are coming from a place where they don't have those same kinds of constitutional principles necessarily. So
Right.
that's definitely a good thing to shed light on. But I think that's fascinating that it didn't actually start with the presidency for you. It actually started with other cases, and
Correct.
I'm sure there's countless examples throughout American
Mhm.
history, federal, state, and local level that you can point to, and I give it a couple of them come to mind. But let's move to the main reason for this discussion, and that's your book. So, why write your book in the Supreme Court's own words, and what do you want people to get out of it?
So I wrote the book for three main reasons. One is because issues of executive power is very much in the news today. We have a president who is engaging in certain kinds of actions where people have strong feelings on both sides of it. And many issues regarding presidential power are now coming before the Supreme Court. So I wanted to not necessarily look at sort of the contemporary surroundings of presidential power, but it motivated me to do sort of a deep dive into the history of Supreme Court decisions, landmark Supreme Court decisions, where the Supreme Court had to address issues of whether the president was acting within his Article 2 powers or was acting in excess of it. And that's exactly what the book does. It starts from 1803 and works its way up to 2024 and curates landmark decisions where the Supreme Court has challenged the President of the United States, sometimes agreed with the President of the United States that the President was acting within his constitutional powers, but in many instances has not. So one reason for the book was I wanted to use sort of the present day circumstances to collect up all of the or the landmark decisions of the Supreme Court from the founding of the nation to the present time, because it reflects upon an issue that is very much in the news today. Another reason why I wrote the book is that I wanted to make Supreme Court decisions more accessible to people. There's no question that most people do not read Supreme Court decisions. And indeed, it can be daunting. Sometimes they can be complex, sometimes they can be dense. Sometimes some cases produce more than one opinion. You could have a majority opinion, a concurring opinion, and dissenting opinions. And as a result, I think many people sometimes shy away from delving into Supreme Court decisions and sometimes rely instead upon newspaper headlines or internet headlines to inform them about Supreme Court decisions. Well, I wanted to write a book where I would quote many of the passages from Supreme Court decisions to show people that reading Supreme Court decisions is not as daunting as some people may make it out to be, but rather to get past the newspaper headlines, past the internet headlines, and to actually show people what the Supreme Court has said on this particular issue, presidential power, from the founding to the present day. So one reason for the book was to make Supreme Court decisions more accessible. The third reason why I wrote it was for the current members of the Supreme Court. In fact, I dedicate the book to the current members of the Supreme Court as a reminder to them of what the Supreme Court as an institution has said from 1803 to 2024 on the subject of the excesses of presidential power, to remind the court of what kind of cases it dealt with in the past, of many of its eloquent passages in its opinions, where it has reined in the president. And indeed, I sent the book to each of the members of the Supreme Court and got responses back from 3 of them. So another reason the book was written was to, as sort of a historic reminder to the current members of the court, here are examples in the past where you have confronted and dealt with presidential excesses, which is, again, an issue that's very much in the news today. So those are the 3 main reasons why I wrote the book. In terms of what I would like people to take away from it, which was the second part of your question, there would be a couple of things, just 3 things, 3 quick things. One is I would like people to develop a deeper appreciation for the separation of powers. The Constitution was built on one constitutional edifice, one idea, and that was the separation of powers, because the founders of this country came from countries and also experienced it in colonial America, where they came to the conclusion that if power concentrates in any one particular branch of government, that is the beginnings of tyranny. And the Supreme Court has spoken eloquently on the subject of separation of powers throughout the decades and centuries, and I collect up those cases so people could read them. So one takeaway is a deep appreciation for the founders' embrace of the notion of separation of powers. Another takeaway would be is for people to have a better understanding of how truly unique the judicial branch of government is. It's really different than the other 2 branches. The other 2 branches, the legislative, Congress, the executive, the president, deal with policy-making matters. The Supreme Court and the judicial branch do not. And one takeaway is for people to have a real good appreciation for the role that the judicial branch and the Supreme Court plays in our system. The last takeaway, and this is at the heart of the book, is that the Supreme Court has spoken eloquently over the last several centuries on how the president is not above the law. And the book collects up various instances where where the Supreme Court has illustrated that point. And we can get into several of them during the podcast today. So those are the 3 main takeaways that I would like people to have upon reading the book.
Gotcha. Yeah, the thing about the accessibility, and I'm definitely going to ask you a little bit more about that, but that is part of the problem with politics in general, is just this information is it's hard to access it. It's either hard to access, or people know where it is, but they don't have the time to research it, or they have some semblance of research skills, but they don't really know how to actually get takeaways from that information. So I can always really appreciate the accessibility part. And something that just occurred to me, and it may have occurred to me before, but and when you talk about the separation of powers, and sometimes I feel some people don't really appreciate the whole concentrating power in one branch, because especially today with how much people, their perceptions are colored by their parties, is it's also just not efficient to have one branch do everything anyways. It's more efficient to have the judicial branch interpret laws, legislative branch write laws, the executive branch execute laws. But I guess that might be a little bit out of the purview of this discussion. So let's get a little bit more into the accessibility part that you were talking about, because like you said, this legalese and the discussion about law, it can be very opaque and hard to understand for the general public. So give us a little bit more detail about how exactly you try to make it more accessible for regular citizens to read, especially when it comes to these cases about presidential power.
So, as I say in the introduction to the book, I have no problem doing the heavy lifting in terms of reading Supreme Court decisions. I've been doing it for 40 years now, and I enjoy it. because I like to see what the court's reasoning is and why it reached the decision it did, either the majority or the dissenting opinions. So one purpose of the book, again, was for me to do the heavy lifting and to uh, uh, sort of write the book in a way that people, the general readership, could understand without getting into the technicalities and all of that. I try to strip the book of all the technicalities, and because some of these opinions can be dense, there's no question about it. Hey, it's tough for lawyers to even get through some of these decisions and the like. What I would really impress upon the viewers is that if you're interested in sort of bypassing the newspaper headlines and the internet headlines and look at what the Supreme Court has actually said, which is why I called the book that it did, in the Supreme Court's own words, to look at the Supreme Court's own words. All the decisions by the Supreme Court, as well as other divisions of the judicial branch, are public. They're public. They're accessible on the internet, and there's a service that summarizes the opinions at the very beginning, so that before you even get to the opinions, majority, concurring, dissenting opinions, there is a summary of the court's decisions right at the beginning, and they're excellent. So I would highly recommend that people. It's okay to read, media accounts, but just keep in mind that sometimes media accounts, depending on what the source of the information is, sometimes sees decisions, Supreme Court decisions, judicial decisions generally, through a certain lens, through a certain ideological lens. And sometimes when they condense it down into a headline, I have found that many times they're not accurate, or they're not inclusive. They're not providing sort of a full-throated explanation of what the Supreme Court's actual decision was. So I would highly recommend that if people are interested, not in addition to reading my book, which tries to do some of the heavy lifting on the reading of Supreme Court decisions, is that if a major decision comes up, for example, the Supreme Court's going to be deciding the constitutionality of President Trump's tariffs. That decision, they just had the oral argument. The decision will probably be out in a couple of months, and there'll be headlines about it. My suggestion to people is don't rely on the headlines. Go to the opinion. They're public, and before the opinion, there is a summary, and you can actually read what the court, in a very condensed summary fashion, can read what the issue was, because sometimes there's confusion about that, what the issue was, what the Supreme Court decided, what its reasoning was, and can do it in a more condensed fashion. And that could substitute. I always think that people should read the opinions themselves, but at a bare minimum to read those opinions. So in terms of accessibility, it's all public. And I would bring up the opinion on the internet and read the summary beforehand. And then as an exercise, compare it to the media accounts that you're being given and seeing whether or not the media accounts are accurately portraying. So if I had one big suggestion on accessibility in addition to my book, it would be that.
Gotcha. And that was something I meant to bring up earlier too. So I appreciate you talking about it. When you talk about this accessibility, a lot of times people, whether they're deliberately trying to obfuscate rulings or they just can't get past their own biases, they paint these rulings in a certain way, and it doesn't really necessarily inform people. It just gets their side mad or happy, or the other side mad, depending on what the issue at hand is. And you talk about the summaries. That's really nice to hear, because there you have some of these other places like Oye, for example. For those of you at home, Oye is actually spelled Oyez, but it's a website that has a lot of summarized information about some of the most important Supreme Court cases we've ever had. And there's also places like Cornell Law too. But
I was going to mention Cornell Law is excellent,
yeah,
and they've been doing this for a long time. So the Cornell site is an excellent place to go to.
Yeah, exactly. I was actually going to ask if you had any in particular to recommend. So I guess Cornell would be the top for you then?
It would be. But even if you just go on the internet, because sometimes news organizations will give you the link to the actual opinion. And many times the link will go right to the opinion. Other times it will bring you to that summary that I talked about. And the summary is really, really excellent. But I would go to Cornell. Excellent resource.
Okay, perfect. Yeah, and it is as great as a lot of those other sites can be. It is hard to beat the original source because that's where all the information is coming from. So, moving on to some more specific instances that you feel that the boundaries of presidential authority have been challenged. So, what do you think are 2 to 3 particular constitutional restraints that presidents from both parties have been guilty of overstepping? And what are some examples from both parties, whether more recently or historical, that you've seen?
So historically, it is true that presidents from both parties have been reined in by the Supreme Court of the United States. It's not just one party over another party. When you look at it, and this is one of the reasons why I wanted to do sort of a deep dive to get out of our contemporary circumstances and look at it historically. There have been many instances where Republican presidents, the Democratic presidents have been reined in by the Supreme Court. So let me give just a couple of examples historically. My introduction talks about the famous Youngstown case in the 1950s involving Democratic president, or he was a member of the Democratic Party, President Truman. President Truman, during the Korean War, nationalized the U.S. steel mills. Why? Because there was a war going on, the Korean War. And in the 1950s, you couldn't run a war without steel. And the labor unions were threatening to go on strike. Truman tried to get the matter resolved. It didn't work. So what did he do? He ordered his Secretary of Commerce to nationalize the United States steel mills. That issue went up to the Supreme Court. Supreme Court said in no uncertain terms that President Truman was acting outside any authorization from Congress. Congress never authorized the president to do such a thing. And that there was no provision in Article 2, which is the article of the Constitution creating the executive branch, including the president. There was nothing in Article 2 which gave President Truman the authority to nationalize an industry, a private industry. And as a result, the Supreme Court invalidated President Truman's decision. So that would be an example, one of the historic examples, where the Supreme Court stood up to the president and said, no, you can't do that. Other instances involving a Republican president would be George Bush, second George Bush after 9/11. The Congress issued a rather broad authorization for President Bush to take whatever actions he believed it was necessary in order to respond to the 9/11 terrorist attacks. The President Bush used that authorization to invade Iraq. And so there was large issues of whether the Supreme Court, of whether the president was using an authorization from Congress well beyond the bounds of what was permitted. And one case did go up to the Supreme Court where President Bush used that authorization to try to justify military tribunals of enemy combatants. In the Supreme Court, that issue went up to the Supreme Court. Supreme Court said no to President Bush, saying that this is a country of due process. Even enemy combatants who are particularly American citizens who are detained abroad are still entitled to the due process rights under the Constitution, and held that military tribunals or holding enemy combatants without any due process rights violated the Constitution. A Democratic example would be President Obama, although this issue never went up to the Supreme Court, I don't believe. But in 2011, he authorized military attacks against Libya, citing his powers as commander-in-chief. There was large constitutional issues as to whether or not President Obama was exceeding his constitutional powers. So there's been many examples. Other historic examples would be President Lincoln. during the Civil War. President Lincoln suspended what is called habeas corpus rights under the Constitution. One person, Mr. Milligan, was imprisoned pursuant to that. He had no allegiance to either side on the Civil War. He was not politically active. The president ordered his imprisonment for 18 months. And the case went up to the Supreme Court. The Supreme Court ruled in favor of Mr. Milligan that President Lincoln had gone beyond his Article II powers in terms of imprisoning someone for 18 months without charge, without due process rights. So that would be sort of another famous historical example. So these would be a couple of examples. Other examples have come up in the context of executive orders. President Biden used an executive order to try to put in place a student loan forgiveness program. Supreme Court did weigh in on that question and ruled that President Biden's executive order is a violation of the Constitution and the like. So there has been many examples on both sides where the Supreme Court has been called upon to determine the constitutionality of either a Democratic president's actions or a Republican president's actions. And these are just a couple of examples.
War powers and the executive orders seem to be in particular to cases of constant controversy in that regard, and especially when one side complains about the other overstepping their war powers, and then the other one does the same thing to the other side, and the same thing with executive orders. I'll actually get a little bit more on that track later on during this interview, but yeah, I think what is just made me think the war powers and executive orders, that tends to be particularly common sources of complaints and has only become more so over time.
Correct. And the source of the tension on war powers is Article 1 says of the Constitution says that only Congress can declare war. Only Congress can create an army or a navy. Article 2 establishes the president as the commander-in-chief. And so there's always been tension between that part of Article 1 and that part of Article 2, where presidents who generally do like to push out, they like to push out to see how far their powers can go, have used the rationale that they are the commander-in-chief and therefore they can order military actions without necessarily authorization from Congress and the like. And the Supreme Court, quite frankly, has struggled with that issue. And you're right. Democratic, Republican presidents have ordered military strikes, not necessarily with any authorization from Congress. And I gave a couple of examples. So that is a tension that the Supreme Court will continue to sort of grapple with as time goes on.
Right. And actually, speaking of this schism, if you will, sometimes between Congress and president, a lot of the discussion about presidents and whether they've expanded their powers too much isn't just about whether presidents have seized that power for themselves. Sometimes it's been criticism that the U.S. Supreme Court and Congress have willingly ceded power to the president. Do you think that criticism is warranted? And if so, what are some examples?
So there's some historical examples of that. And it has come up, at least constitutionally, in the context of what's called the delegation doctrine, or what's sometimes referred to as the non-delegation doctrine. There have been instances in American history where Congress, for example, has delegated some of its Article 1 powers to the president because it's felt that the president and the executive branch would be a more efficient branch to implement something. We just recently saw that with the pandemic, where Congress passed several laws which empowered the executive branch to take quick action on what was clearly a national emergency, international emergency, and the like. And the Supreme Court has dealt with that issue historically, and they've dealt with it. And it just came up in the recent tariff case on non-delegation doctrine. Just to provide you with sort of a historical example of kind of at least some of the genesis of this. In the 1930s, during the Depression, this country was involved in a severe economic downturn, the Great Depression, which began in 1929. And Congress was passing all sorts of laws to give President Franklin D. Roosevelt and the executive branch lots of powers in order to deal with the Depression and then later on World War II. Well, one of those areas, particularly, believe it or not, came up in the area of a monopoly of the chicken business in New York City. Believe it or not, this is an issue that came up to the Supreme Court, where New York City had kind of a monopoly on the sale of chicken to consumers. And it was becoming a monopoly. Well, the Congress, as part of Great Depression measures, gave President Roosevelt carte blanche authority to basically regulate the chicken consumer industry. No standards, just here you go. We're delegating our authority to you to regulate this industry because generally Congress is the one that has the power to regulate interstate commerce. Well, that issue went up to the Supreme Court. And the question is, could Congress do that? Came up in a silly kind of context, chickens and the consuming of chickens. But that's the posture that the case went up to the Supreme Court. Could the Congress delegate basically carte blanche legislative authority to the president? Supreme Court said no, not this way at least, that the Congress cannot just delegate its authority without any intelligible principles, is what the Supreme Court said, to the executive in order to carry out what is arguably a legislative function. So that would be an example where the Supreme Court stepped in and said delegation under some circumstances is okay, but not this way. We just saw this with respect to the tariff case, just to use another current example, where there is a federal law where members of Congress, as well as President Trump, is arguing that Congress, when it passed this law, it's called IEPA, we don't need to know the name of it, but it passed this law, which delegated to the president tariff-making authority, even though that power is with Congress in Article 1. And that is one of the issues that is currently before the court today. The oral argument in that case was last week, and the non-delegation doctrine came up in that context. And several of the justices expressed concern that if this is what Congress wanted to do, it wanted to delegate that kind of large authority to do worldwide tariffs, that raises issues of the non-delegation doctrine, and it raises issues about whether or not that's really what Congress intended. So there have been many examples where at least the Congress, their actions have been called into question as to whether, when they delegate to the president certain responsibilities that arguably are Article 1 responsibilities, legislative responsibilities, but delegating that to the president, is that a constitutional transfer of authorized power? And we're seeing that being played out today in the tariff case. On the Supreme Court side, because you raised not just the Congress, but Supreme Court as well, the answer is yes. And just one recent example would be the presidential immunity case from last year, 2024. In fact, my book ends with that decision. From 1803 to 2024, it ended with the presidential immunity decision. Some would argue that the Supreme Court in that case ceded too much authority to the president to engage in unlawful action. Supreme Court in that case was called upon to determine whether or not President Trump could be criminally prosecuted for certain actions that he took while being president. And the Supreme Court, even though the Supreme Court's been around for over 230 years, never dealt with that issue. Never came up, except now. When are the circumstances when a president can be criminally prosecuted for actions taken while in office? And the Supreme Court struggled with that and did provide the president with some immunity with respect to powers that are expressly given the president under the Constitution and in other circumstances. There were heated dissenting opinions by several of the justices who believed that this was ceding too much power to the president, that it's going to allow the president to get away with too much criminality. And that issue is going to continue depending on what type of factual circumstances come to the court in the future. So this would be a couple of historical and present examples of where it's been argued that Congress has ceded too much of its power to the presidency, thereby expanding the powers of the presidency, and arguably a situation, although there's debate on the subject, where the Supreme Court recently may have done the same.
I think something that you really highlighted there, and I've talked about it in a previous episode of the podcast. It was actually just me that time, and it's something I've been wanting to work with more in some way. I haven't really figured it out yet, but it's this dichotomy between efficient versus deliberative government, and really trying to get this idea in people's heads of, do you want the government to be quick acting in XYZ situations, or do you want them to ponder things more? And you're talking about Congress ceding authority to the president in the name of efficiency. I think that's a perfect example of the, well, do you want to do that? Efficiency, yeah, you might get a quicker solution, but it might lead to more of an abuse of power. Right. If you do a more deliberative process, a lot less likely to be an abuse of power, but also you can really bog things down and make it inefficient. A lot of people complain about Congress being gridlocked all the time. So I just thought that was a nice way to really think about government in general, and yours was a really good example of that.
So can I respond to it? Can I respond?
Yeah, go ahead.
You really put your finger on something that the founders discussed in the Philadelphia Convention, the Constitutional Convention in 1787. Do we want an efficient government, or would you want a deliberative, non-tyrannical government? And the founders unequivocally decided in favor of creating a government that wasn't necessarily efficient, but was trying to create a government that would not collapse back into tyranny, and realized that the best way to do that was to spread out the various political and lawmaking authorities among three branches of government, some overlapping powers between each of the three, but each jealously independent, jealously guarding their powers, that is the best way to distribute, to divide up government so that it doesn't collapse back into tyranny. So the founders, and then the founders acknowledged, the Supreme Court acknowledged from the founding of this country, that this can lead to inefficiencies. But efficiency was not the goal of this government. It was endurance. The founders wanted endurance because they looked at the course of human history, James Madison in particular. He spent about 8 to 10 months before the Constitutional Convention in Philadelphia by his farm in Montpelier, Virginia, which is not, I point him because it's not far from me. And he spent about 8 or 10 months before the Philadelphia Convention reading every book he could find, including Thomas Jefferson sending him books and manuscripts from France, because Thomas Jefferson at that time was our ambassador to France. James Madison read every book he could find on when do democracies and republics succeed and when do they fail. And one of the lessons that he concluded was that it's the concentration of power in lawmaking power in one branch that leads to dictatorship, it leads to anarchy, it leads to anti-democracy. And so James Madison, as well as the other founders, went into the convention realizing that the best way to create this government was to distribute the powers amongst the three branches, legislative in one, executive in one, judicial in one, have some overlap between, have some cooperation between the three of them. And there's many examples of that in the Constitution, but to keep them separate so that power doesn't get concentrated in one particular branch. And so the founders opted in favor of endurance over efficiency. And there's no question that many times it can lead to inefficiencies and slowness. But here we are, well over 230 years, through all sorts of ups and downs. a civil war, slavery, post-slavery, a Great Depression, two world wars, scandal after scandal, recently a pandemic, and here we are still standing. And it really is a testimony. And this is one of the themes that I'd like people, you talked earlier about some of the takeaways. Another great takeaway would be sort of a deep appreciation for the founders of this country. They had their flaws. There's no question about it. They punted on the issue of slavery during the Philadelphia Convention of 1787, which arguably contributed later on to the Civil War. They had their flaws, but they crafted a government, a democratic government for a republic that has lasted all these years. And so it may be inefficient, but it has endured, which was their goal.
Yeah, and unfortunately, you're never going to have a flawless document or system of government when human beings are involved. But you saw some of those concerns also borne out with the Articles of Confederation too, where too much power concentrated in the legislative branch. And then,
Right.
funny enough, though, the Constitution both made it more deliberative and more efficient compared to what we have with the Articles of Confederation.
And also not just legislative. One of the lessons that James Madison and some of the other founders learned in their study of human history on democracy and republics is that majority rule can be dictatorial. Majority rule can be too much democracy can lead to tyranny. And that is why the Constitution was crafted and is crafted as it was, basically limiting the participation of the citizenry. I mean, originally, citizens, their main way of participating was directly voting for members of the House of Representatives, which was one half of the legislative branch. At that time, the original Constitution did not allow citizens to vote directly for senators. That was decided by state legislatures. It was decided by the people's elected representatives in the state legislators because it was felt that the people could not be trusted to vote for their senators. Same with the president. The president is not directly voted on by the citizenry. It is filtrated through this electoral college that the founders put into the Constitution to limit the citizens' involvement in the selection of the president. The idea would be that it would be more of the elite who would be able to select the president. And then, of course, in the judicial branch, at least at the federal level, the citizens don't participate at all directly. They vote for the president, who nominates people for the federal bench, confirmed by the legislative branch, and of course they serve for life. They're not up for elections. So one of the lessons that James Madison drew was that we want the citizens to participate, but not too much, because history has shown that if you allow citizens too much democracy, that can lead every bit as much to tyranny as concentrating power in one particular branch of government.
Yeah, that also made me think one last thing before we move on to the next question, because you were talking about how U.S. Senate used to not be popularly elected, and obviously the president is he is directly elected, but technically indirectly elected because of the electoral college. But in my research on state partisanship history, which I'm hoping to release in the near future, because state legislatures and state politics in general has a very quirky history in a lot of ways. And there were actually even a few states that governors were not directly elected either. They were actually chosen by state legislators. So kind of in that similar vein to the U.S. Senate. But I do want to keep more on this, the interbranch relationships. So we sometimes hear about this political questions doctrine. And for those of you at home who don't know what that is, it's basically the Supreme Court declines to step into certain conflicts between the president and Congress by just letting the executive and legislative branches sort things out. They try not to favor, the idea is they're trying not to favor one branch over the other. What for you, Peter, though, what is your take on the political questions doctrine? And do you think that this has also contributed to an increase in presidential power?
So the political questions doctrine developed a long time ago by the Supreme Court, and it was created as a doctrine basically to rein the Supreme Court in, to rein the judicial branch in, uh, because under the Constitution, the creation of laws, policy decisions on, what's good healthcare policy, what's not, should we go to war, should we not go to war. The Constitution in Articles 1 and Articles 2, creating the legislative and the executives, leaves those kinds of questions to those two particular branches and not to the judicial branch of government. So the political question doctrine was developed by by the Supreme Court as sort of a self-monitoring to make sure that the court and the judicial branch as a whole does not delve into questions of law or policy that are at least expressly given to either Congress under Article 1 or the executive branch under Article 2. And so if a case comes before the Supreme Court where the Supreme Court believes, that really deals with inter-branch conflict between the legislative and executive branch, it's really not, we're not being called upon here to determine the constitutionality of anything. We're not being called upon to determine whether or not the president is acting within the confines of a statute, a law passed by Congress. It's really interbranch fighting on policy and law creating matters between Congress and the president. So we, the judicial branch, are going to stay out because we're really not being called upon to decide anything here. And indeed, the Supreme Court, from the beginning from the founding of the nation, has been very careful, and the book talks about this as well, has been very careful to make clear that there are some things the Supreme Court does not do. The Supreme Court, and it's interesting to say this because sometimes people may have sort of a misconception about what is the role of the Supreme Court in the judicial branch generally. Supreme Court doesn't decide policy. The Supreme Court doesn't veto legislation. The Supreme Court doesn't weigh in on what's good policy or bad policy. That is not the role of the judicial branch of government. That's the role of the other two political branches. And the Supreme Court is being called upon to determine, well, if that's what you want to do, we will decide whether the Constitution gives you the power to do it. Or if you, the president, want to engage in this kind of action, in addition to seeing whether the Constitution gives you that power to do it, has Congress authorized you to do this? These are legitimate judicial related questions. Political question is when the Supreme Court, I wouldn't say the Supreme Court, when they invoke political questions, is necessarily giving either the legislative or the executive branch additional powers. At least the Supreme Court wouldn't say that. They would say that's their power. And we're not being called upon, we cannot be called upon to weigh in on that kind of political or lawmaking kinds of decisions. So the way I see the political questions doctrine is it's a self-regulating mechanism that the judicial branch uses to remind itself that our role is limited. Our role is limited to whether the Congress or the president is acting within the confines of the Constitution. That is squarely a judicial question. And with respect to the president in particular, whether the president is acting within his powers under Article 2 of the Constitution and or is acting under a valid law, valid statutory authorization by the president. So I wouldn't see it as an expansion one way or the other. I think it's mainly a way for the judicial branch to mind its own business when there are issues that the other two political branches need to resolve on their own.
Interesting. I don't think I ever realized that it was actually more of a self-regulatory measure for the Supreme Court. I mean, obviously they were the ones that came up with it, but I guess I never really thought about it like that, where they. I think that's also one of those things where, I mean, obviously lots of things in politics are about your perception and perspective, but I think a lot of times people see political questions doctrine as almost like a cop-out from the Supreme Court, and they'll say, well, you're letting one branch or the other is just going to overstep the other, and you're not going to do anything about it. But then at the same time, somebody could turn around and say, well, the Supreme Court does step in on these things, then maybe the Supreme Court is actually taking more power for itself. So I guess
Right.
it is, you got to find the right balance to strike in that regard. And
That's correct.
you actually just kind of touched on this a little bit in your answer. You're talking about how judges or the Supreme Court does not rule on policy. And I think that's a really good segue into this question, where you sometimes hear situations where members of Congress, activists, and quote unquote influencers, they chastise the U.S. Supreme Court or other federal courts, but especially the U.S. Supreme Court, for being quote unquote activist judges when they push back on a president or a president's policies and saying, oh, they're a lot of times they'll say, oh, they're trying to legislate and trying to rewrite laws. What is your take on the activist judge argument? And do you think that is a particularly problematic argument for holding presidents accountable?
So I do think it's partly problematic. Uh, my experience with the judicial activism argument, sentiment, is that it's typically the loser in a case that raises judicial activism, and
You
it
ruled
depends
against me,
upon.
so you're wrong.
Yes,
Yeah.
and so it typically, it's the loser in a case that says that the court did something wrong. It's too active. It's making law instead of construing laws and the like. But then again, it depends upon what your political stripe is. So, for example, there was a string of decisions in the 1960s by the Supreme Court where it started liberalizing the constitutional rights of criminal defendants. That's where we got the Miranda warnings, the Miranda decision that before the police can engage in custodial interrogation, you first have to advise someone of their rights. The rights of indigent criminal defendants to a lawyer, even if they can't afford a lawyer. There was some loosening up, or I'm sorry, there was some more stringent requirements put on law enforcement under the Fourth Amendment for searches and seizures. Criminal law was a big issue in the 1960s, and the Supreme Court weighed in on many of those decisions. And if you're a person who's a political conservative, you would probably be arguing that this was activism by the court. Of course, on the other side of it, including the justices themselves, and there were some dissenting opinions in these cases. These were not unanimous. On the other side of it would be, no, the court is doing what it should be doing, which is to recognize the constitutional rights of criminal defendants, reining in law enforcement so that they don't contravene the Constitution. It depends on what side of the aisle that you're on, but it applies today as well. Many people who would consider themselves to be progressives or politically liberals would see the court more in a conservative bent on many of these decisions, but people on the political conservative ideological side would say, no, the court is construing the Constitution according to its original terms. It's engaging in original meaning of the Constitution. That's always the way constitutional interpretation should be done. So my view on sizing all of this up after several decades of hearing these references to judicial activism is that it depends whose ox is being gored. If you believe that the court is issuing decisions that you don't agree with, it tends to raise these concerns about activism. On the other hand, if you believe the Supreme Court's getting it just right, you believe that they're not being activists; they're doing their job. So it kind of depends upon political ideologies and whose ox is being gored. I think that the way to look at judicial activism is that it's never meant in a positive way. It's always meant in a disparaging way. And that concerns me. And this gets back to why I said I think it's problematic, is that, the confidence, the stature of the judicial branch of government. Judicial branch of government, as Alexander Hamilton said, doesn't have an army. It can't command the respect of the people through force, through coercion, through a tax code, through policy making. The Supreme Court and the judicial branch generally depend upon, their credibility depends upon, to the extent that the American people believe that they are making decisions on the basis of law, on the basis of the facts before them, that they are coming up with reasoned judgments, and the like. And if people start not to believe that, which is prevalent, I would say, in today's society, well, then the credibility of the institution starts to diminish. And so when I hear accusations of judicial activism, not only do I conclude that you were on the losing side of that case, but also I think that it's a disparagement that whittles away at the institutional strength of the judicial branch of government. So it does concern me in that regard, and I tend not to pay too much attention to it. What I would suggest to people, this goes back to piercing through newspaper headlines, getting past newspaper headlines, getting past, the internet displays one side or another on Supreme Court decisions. Same here. Get past the labels. Get past people's accusations, depending upon what their political ideologies are. Get to the decisions. Get to the decisions. Read the decisions. Make decisions for yourself. Use the summaries at Cornell or elsewhere to actually read the opinions. It's a big point in my book, so that, and maybe you'll conclude that the court is activism. Great, but at least it'll be on the basis of what you're actually reading. The Supreme Court decisions themselves, or a really intelligent summary, accurate summary of that. Get past the headlines. So I would say the same here. People getting past sort of the labels that sometimes people append to Supreme Court decisions, and get to the decisions themselves. What was the facts? What was the holding? What was the reasoning behind it? Do you agree or not? That's what I would say with respect to judicial activism.
I think you see a lot of that whole, we have to apply a specific disparaging word or something. We can't just disagree with it or say it's wrong. Maybe they're not activists. Maybe they just have what you think is a bad interpretation of the law. I mean, it's
Right.
not like they haven't had that in the past, especially when it comes to, the lack of civil rights initially, like with Dred Scott versus Sanford or Plessy versus Ferguson. But it kind of is a similar case to when people can't just disagree on policy. They have to call each other traitors or evil or stupid. It kind of makes me think of that. And I think that is a problem that you pointed out there. The legitimacy of the branch has been called into question. I'm not saying that they've been I'm not saying I agree with their rulings recently on various cases. That's for other people to decide. But I think it is a very concerning trend here where we see a plummeting trust in the judicial branch in particular. I mean, Congress has had that kind of thing for a long time, which is also still a problem, but it's a little bit out of the purview of this discussion. But it is, there's nothing necessarily wrong with disagreeing with how a branch of government is, and a lot of times they do need to be criticized and held accountable. No entity is above accountability, but when it gets to a point where you're starting to doubt the legitimacy of it purely because they are doing things that you don't like, I think it is a very serious problem. And speaking of which, do you see a lot of hypocrisy where these members of Congress, activists, influencers, to bring it more back to the presidency specifically, that they'll be more supportive of an expansion of presidential power when it is a president they like? And if so, how much of an issue do you think this poses for our political discourse and democratic norms?
It's a big issue, and you put your finger on it. And I mentioned this in the introduction to the book. I think that far too many people look at the question of whether what a president has done is lawful or not. They confuse that with partisan loyalty. that they see that issue through partisan lens. And one effort I've tried to get across in the book is that the question of whether what a president does is lawful or not is should be determined on the basis of constitutional law. It should not be on the basis of personalities or on the basis of you like him or her, you like their policies or not. And I think far too often people today see Supreme Court decisions, including with respect to the president, as sort of a sum total game. They see it as, well, I don't like this president who's sitting in the Oval Office now, and therefore I'm going to see Supreme Court decisions through that lens. Does it help him or her, or does it hurt him or her? And if I don't like this president, well, then I'll agree with the Supreme Court decision. If it hurts this current president or goes against this president, that may be the opposite kind of thing. That is not the way, at least I would suggest to people, that the lawfulness of a president's action should be seen. Chief Justice John Marshall, who was not this nation's first Chief Justice, but I think he was the third, but he was the first preeminent Chief Justice from the early 1800s, I think, into the 1830s. And he wrote a lot of landmark decisions, including Marbury versus Madison, which established judicial review, and many other decisions. He always said, famously so, this is a constitution that we are expounding here, not policy preferences, not presidential preferences, not whether you like the president or don't like the president. That the question of whether a president is acting within Article 2 powers, whether he's exceeding those powers, should not be seen through the lens of partisan loyalties, but rather should be seen in the context of constitutional law as it is developed from the founding of the nation. And this would be, I think, one antidote to that would be to actually read the Supreme Court decisions themselves, or a really good summary of them, so that you can see that as an institution, the Supreme Court justices, at least in my view, are not sitting around the table saying, how can I help this president? How can I not help this president? I don't think they see it that way at all. I think that they do see it in terms of their precedent on the matter, which sometimes goes back decades, if not a couple of centuries, and trying to decide issues that come up to the court in a manner that is consistent with its prior precedent, in a manner that they believe is consistent with the Constitution of the United States, not whether it helps one particular president or another. So I think that we do see far too much of people seeing the Supreme Court. Now, let me say this. That's not to say that the Supreme Court's not a political body. It is. There's 9 individuals. Whenever you get more than more than one person in the room, there's always going to be politics. That's just the nature of the human condition. But I do get the sense that the Supreme Court doesn't sit around saying, how can I help this particular president or not help this particular president? They're looking at it more historically. And that's one reason why I sent them my book. Why I dedicated my book to them, which is that you are going to have issues of executive power before you. And I wanted to use this book. One of its purposes, as I said at the outset, was to remind the current justices, this is what you all have said historically on the subject of reining in presidents or not reining them in. And I wanted to, write a book that would remind you of what you said historically. So, look, I think that we live in a very partisan age. We live in a very polarizing age where people see things. People are in their information bubbles, and they tend to consult the same news sources and the same news opinions. And there's not a whole lot of venturing out between the bubbles. And that affects the Supreme Court. That affects the views of the Supreme Court, because I think much too much of it is seen through, whether it's going to help my guy or not. And institutionally, the inquiry by the Supreme Court and the judicial branch generally is much broader than that. It really is. And that's one of the reasons why I wrote the book, to try to convey that to people.
Just made me think of when I went back up to Gainesville to see my undergraduate alma mater play my graduate alma mater, USF versus UF in football earlier this year. I went to go visit a friend of mine who was an adjunct professor at the time, and or when I was in grad school, and he still does some adjunct teaching, but he was just talking to me about how when he has his students, he tries to teach them, especially when they have that issue of they're thinking of things through a partisan lens and really trying to instill them. They're not necessarily purposely trying to do that. It's just they haven't really thought about the idea of, okay, you like what this president is doing, but now what if the shoe's on the other foot? What if a president that you don't like is doing this thing that you support? And then you start to get the gears going in their heads, and they're thinking, oh yeah, that's a good point. We have to have rules for everybody. So I think there is some of that, at least for regular citizens. They do sometimes not take that to its logical conclusion, although unfortunately I think with a lot of members of Congress and activists and influencers, they know that they're hypocrites and they don't care, or they just refuse to acknowledge it. And obviously those are issues too. And something you pointed out too is the Supreme Court, they aren't impartial. I forget the exact wording that Alexander Hamilton used in whichever Federalist paper it was, but he basically was saying like that they need to be completely insulated from politics. And yet, I think that's why when he was arguing about having lifetime terms for them, which
Right.
I mean that's another argument that I've talked about in the past, but to some extent, you certainly insulate them for politics. And I would agree that I don't think that they're sitting in a room thinking how they can help this president or help this Congress. But just like any other human, they do have their biases, and sometimes they don't necessarily acknowledge it. But now they do have a lot of information to back them up. Like I remember, not to Nah, I don't want it to make it sound like I'm trying to rag on him. I would say this for anybody who thinks they could, or any regular person that thinks they could take on a Supreme Court in terms of legal minds. But I remember Stephen Colbert was trying to have an argument with Antonin Scalia when he was still alive, and it's just like, Stephen, you're not going to win an argument against Anthony Scalia. But it's the same other way if it was somebody who was a conservative trying to argue against Ruth Bader Ginsburg. You are not going to beat her in an argument. Does not mean that they don't have their own biases that they're contending with, and it doesn't mean that they're not. It doesn't mean that they're impartial, but at the same time, these are still very brilliant people that are, I think, at least the vast majority of them are trying to do what they think is right. And obviously, there are many cases in the past where they have objectively gotten things wrong, like we talked about some of the old civil rights cases where they certainly took way too long to affirm civil rights. But yeah, at the same time, we do have to have a very specific, not litmus test, but it's like a set of principles that we apply to every single president. If this president, if it's a Democratic president and they're overstepping their bounds with X action, it's also overstepping their bounds if it's a Republican president or if it's an independent president. And like you said, I think we unfortunately stray too far from that because we're too concerned about winning as opposed to actually keeping the system running the way it's supposed to. Right. So we are coming up on the home stretch here, but before we get to those final few questions, near the end of interviews, and I know you talked about already how you try to keep things as practical as possible, which I really appreciate. So I want to hone in on those practical applications for anybody who's listening or watching. What are 2 to 3 practical ways that listeners for this episode can hold presidents accountable for overstepping boundaries, especially for those citizens who are the same party as the president, whichever president it is?
So I mean, at least one thing comes to mind, and that is many people, many constituents do speak with their elected member in Congress. And what I would advise people to do, including people of the same party as the president, whether the president happens to be Democrat or Republican, is to put aside as best you can partisan loyalties and tell your elected representative to defend the Constitution and not necessarily defend the president. Huge distinction between the two. And I think far too often on both sides of the aisle, people place their allegiance with the person instead of the founding fundamental document of the country. So one practical thing I would suggest to people when they meet with their Congress people or they meet with their senators is to make the point to them that they expect them to defend the Constitution and not necessarily the president, whatever party the president happens to be in. That would be one practical application. A second practical application I'll mention it again. Read Supreme Court decisions. There are sources out there, including Cornell, or the opinions themselves, where you can dive through media presentations of on one side of the other and read the decisions themselves and come to your own conclusions about whether you agree or disagree. The other major thing that I would suggest is voting. People vote. Voting is one of the most practical things that we can do in this country. And I would suggest to people, maybe this is asking too much, is to not necessarily vote on the basis of party affiliation, but vote on the basis of defending the Constitution and in particular the separation of powers. It is always a dangerous thing, I believe, for American democracy, for the Congress of the United States to be both chambers, to be of the same party as the sitting president. We have that today on the Republican side. We've had that before on the Democratic side. I do believe strongly in checks and balances, and I believe that should primarily come, and I know the Supreme Court would say this, the checks and balances mainly should come between the two political branches themselves. Yes, it leads to less efficiency, more gridlock, no question, but each acts as a check upon themselves when the Congress of the United States is controlled primarily by one party and the president is of the other party. It does lead to inefficiency, but it also reduces the chances of there being a concentration of power in one branch or another. So I would ask people to vote not as much on party affiliation, but rather on the basis of separation of powers. That's a tall order because much research has been done in this country about partisan affiliation is probably the predominant factor upon affecting voting. And it's a problem. It's a problem. But I would invite people to think about whether to vote on a different basis and a more constitutional basis to make sure that the checks and balances, particularly between the Congress and the president, can take hold and take effect in terms of preserving our government.
And it is good to also note with this efficiency versus deliberation debate, even if a government is taking swift action, doesn't mean that action's good. And it's also the same way if it's a deliberative government, doesn't mean they're coming to the right conclusion either. But
Right.
You do need to make sure that it is the process we want and we have good reasons for why we choose the process we want. And as an addendum to what you were saying at the beginning, I would agree with obviously defending the Constitution, but I also want to encourage people to also make sure that when they call their member of Congress to defend the Constitution, make sure that that is not just a euphemism for defending your party, because a lot of times people's opinions of what the Constitution says are still unfortunately colored by their party and which party is in power. So I would also encourage people to think about that as well. So we are just about out of time. So we are going to go ahead and move on to the random question of the day. If you are new to this podcast, I like to pose a random, fun, non-political question to my guests just to round things out and make things a little bit varied and get another side of the guest. So, Peter, for you, today's random question of the day is, what is the silliest, dumbest, whatever legal case you have ever seen or tried, and what exactly happened?
Oh my goodness. Where to begin? Where to begin? Well, so I was working on a sexual harassment case because I did a lot of employment discrimination law under Title VII of the Civil Rights Act of 1964 and a host of other federal anti-discrimination statutes. And this wasn't in court, although we have some there. This was before it went to court, and we were at a mediation. And I'm not going to mention any names. And mediation is sometimes a former judge will come in to see whether or not they can mediate the dispute before, so that there is no trial and to save everyone the time and expense. And it was a sexual harassment case where the client was alleging that she was the victim of all different kinds of sexual harassment by a certain male individual in the workplace. And as I was going to when I was driving to the mediation, I noticed driving there that there was this new Chinese restaurant on the side of the street. And I'll come back to that. But I noticed the new Chinese restaurant. So I go to the mediation, and before we actually do sort of the plenary session where we're all together in the same room, the judge, former judge, but we always called him judge, he would, came over to, he said, "Peter, come over here." And we went to a separate room where the employer's lawyer was. And she and the judge said, "Peter, you may want to take a look at this." And keep in mind, I had a client that was seemed very honest and straightforward. And the other lawyer just kind of opened up this folder and saw all sorts.
Sorry, real quick. Was your client the woman, or was it the male?
It was the woman.
It was the woman. Okay.
And she was alleging the sexual harassment. So the other lawyer kind of opens up the folder and says, "Peter, take a look at this." And it was my client in, how shall I put this, in various states of undress, engaged in certain kinds of activities that one wouldn't think would occur at the site of employment, or let alone be on camera and on film. And at that point, the judge kind of looked at me and said, "Well, so Peter, what do you want to what do you want to do here?" So I went back to the client, and she ranted and raved that this isn't true, and that was her boyfriend, and this kind of thing. Of course, it blew the case up. And it's kind of hard to argue sexual harassment when you've engaged in these activities and it's caught on film and caught in photographs and the like. So long story short, the case was settled for dirt cheap. And on the way back, because it ended after like 2 hours or so, I was able to have a really nice lunch at that Chinese restaurant on the way back. So that's one that kind of stands out it was kind of, an embarrassing case, but it happens. I've had hundreds, if not thousands of cases, and there's bound to be a couple that stand out, but that one surely did.
Yeah. Yeah, I can understand. So obviously, I have never tried a case. I am not a lawyer. I've never a lot of people I knew back from my undergrad days at University of South Florida. They were all obviously, a lot of political science people want to go on to law school. I knew that was never what I wanted to do, but I still find law fascinating, and that's part of the reason I have you on here. But I remember back in high school, I guess it was called Intro to Law, and I just remember several cases from there just being not only that the case itself was stupid, but that the plaintiff actually won the case. That was what really boggled my mind. I remember the one time, the one where a lady, she put on her cruise control for Winnebago to go make a sandwich. And of course, cruise control does not actually go with the twists and turns. And so, but I think she sued Winnebago for basically not describing what cruise control actually does, and she won. So Winnebago has that in their user manual. And then there's another one I remember reading about somebody. He broke into this couple's house when I guess they were on vacation, and for some reason he could not get out of the house, and they just had cans of Pepsi, I think, and he basically had to subside on those. And then when he got home, he actually sued them for mental distress or something like that, and I think he actually won that case. I had to go back and find that, but it's just like, we're kidding, right? This is not like, even if it's like technically, I guess, even if there's technically a legal justification for it, just like the stupidity of some people is like, we shouldn't be rewarding that. But
so talking about stupidity, I have one quick example, another case that just came to mind. So I represented someone who was sued. He was actually the defendant in this employment case, and he was sued by a colleague, and he and others played a practical joke on their colleague in the workplace. And their practical joke is that they got what looked like to be dynamite, real dynamite. It looked like it. From a glance, it certainly looked like it. Of course, it wasn't. And they put a timer on it, and they put it in her credenza in her office. And after a while, they detonated it, which means that the clock started ticking down. She wanted to know where the ticking was coming from. She opened up the credenza, and she thought she saw what was dynamite.
yeah,
And she went flying out of there. And she ultimately did sue the employer, and she sued my client for all sorts of claims. The case ultimately got resolved. But, in the scheme of stupidness, things that you should never do, that would rank on the list as well. It was well-meaning, believe it or not, but, you maybe you ought to think these things through before you carry them out.
Yeah. That's some people just really don't think things through. And I know there are times where I don't either, but that is not something I would do. Certainly, that's not my idea of a practical joke. But
right.
But yeah, it is just amazing how even in these cases that you think are just so dumb, sometimes they work out in a way that you don't expect. Like the judge is really going to rule for them, or the jury's going to really rule for them. But
right.
Sometimes it's just how it goes. But anyways, that is going to wrap things up for today's episode. Peter, thank you so much for coming on. Real quick, any links that you want to share? Obviously, I'll put your book in the show notes, but anything else?
My book is on Amazon. All you have to do is put in the words in the Supreme Court's own words, and my book will pop up.
Well, there you go. And then for my show notes, or my links, my Facebook, Paul Rader, author and speaker, my LinkedIn profile, my medium.com profile, where I write on from time to time, my email, paulraderwrites@gmail.com. My 5-day educational email course about how we can all more effectively mitigate polarization, because some of the ways that we try to mitigate polarization is not effective and sometimes actually makes it worse. And my website, paulrader.org. So that should be all those links. So as always, thank you so much for listening and tuning in.
Thanks,
and we'll see you next time. Thank you, Peter.